And just with the time that we've got remaining before we look to wrap things up, I'd like to take a brief moment just to ask both of our panelists for their key takeaways or their final thoughts from today's presentation. Stephen, we heard from you first. Perhaps you first want to close us out with a few of your key takeaways.
Yeah, like I said, I hit on kind of three topics there. I think that the key takeaway with respect to arbitration clauses, with respect to drafting, be clear and concise. Obviously, that goes with virtually anything, but specifically with arbitration clauses, be clear, concise, and direct. And then, just remember, if you're in an arbitration, really in terms of getting through the arbitration, the key is consent, agreeing with your adversary. A good working relationship with your adversary makes your life a lot easier when you're in an arbitration. With respect to integration clauses, again, they're very, very useful. If you're trying to knock out and preclude prior agreements, you might want to think about an anti-reliance provision coupled with an integration clause if you're seeking to really cabin everything that the parties' relationship is about to that one agreement. So some takeaways there. And then on the duplicative nature of tort and contract claims, really, again, for litigators on the phone and maybe those in-house that are more often than not on the defense side, when you get served with a complaint, if there's a host of claims, take a look to see which ones sound in tort and which ones sound in contract, and look for overlapping conduct that really sounds in contract, and you might be able to knock out quickly the tort-based claims and skinny the dispute down to what's really important.
Thank you so much, Tracy. We then heard from you. Perhaps you want to cap our presentation today with a few of your key takeaways as well.
Sure. On the indemnities part, I think that it's important to remember that the anti-indemnity acts in 45 states don't apply to all contracts. They only apply to the contracts that the statute is designed to protect or apply to. So, you really have to know the anti-indemnity statutes, and then you have to know what the case law requirements are generally for the state that is governing your contract about how to draft, how to craft an indemnity provision. And like I said, generally, it's got to be set off, it's got to be in bold, it's got to be unmistakably clear about what your intentions are with respect to that indemnity. And on those waiver of reliance clauses, I think it's really important to remember that distinction, that the clause should disclaim reliance and not disclaim reliance on any extra contractual representations, and not merely mention that there were no extra contractual representations. That is a distinction that has a difference, and it's important. So even in Delaware, where they say that we don't have magic words, the best practice is to include clear and unequivocal disclaimer of reliance on extra contractual representation language.